These forced union dues are a critical cog in the corrupt bargain that is crushing taxpayers.
Hello and welcome to another edition of Only in Illinois, your weekly video recap from Reboot, Illinois. I'm Madeline Dubeck here with Matt Dietrich, and this week the governor didn't just talk about union bosses, he took some action. He signed an executive order saying that people who are in unions but don't really want to be in them, who are state workers, can have their what's called fair share portion of fees, I guess you would call it, set aside into an escrow account as a court case gets worked out. At the same time, he actually filed a suit in federal court.
Right, he filed a motion in federal court that he hopes will be accepted, make its way to the Supreme Court and be accepted, and will...
The U.S. Supreme Court.
Right, and will decide this issue once and for all.
In light of the Supreme Court's decision last year in Harris versus Quinn, it is clear that the so-called fair share provisions of the current collective bargaining agreement are also unconstitutional. This morning, I signed an executive order that ends unfair share fees for those employees who wish not to fund government unions with which they may disagree. We know this issue ultimately must be decided by the Supreme Court. So we are also simultaneously filing what is known as a declaratory judgment action in the federal court, asking ultimately that the Supreme Court declare that these fair share provisions are unconstitutional.
This goes back, of course, to throughout Rauner's campaign. He had talked about corruption, public employee unions, and government, the whole negotiation, the dealings with them, the unions making political contributions, that was all a very corrupting process.
And corrosive and so on and so forth.
Exactly. That came up during the primary election.
Right.
He put that talk away during the general election, and then after he was sworn in, he revived it and started talking about his desire to see the union's ability to operate as a political entity dampened as much as he possibly can. The unions say that, and state law says that these fair share fees collected from non-union members cannot go toward political activities. They're separate, and they only cover the cost of administering this contract and enforcing it.
But Rauner and others make the argument that you may say that, but you can't literally in practice separate the two.
And government union bargaining and government union political activity are inextricably linked.
The argument is that in a private sector union, when you're negotiating for salary and benefits, you're negotiating with the employer. When you're a public sector union, you're negotiating with the government. Therefore, everything you do is political. Therefore, you can't separate the two.
Because you're in essence lobbying them like any other entity would.
Right. Now, the reason this comes up is because of a U.S. Supreme Court decision from last June called Harris versus Quinn, and that is a case that was based on Pat Quinn, and that's a case based on Pamela Harris, who is a mom from Winthrop Harbor, Illinois. She is a caretaker to her disabled adult son, and she gets her son gets a Medicaid stipend, gets a Medicaid payment, and like in a lot of these cases where you have a home health care worker, a relative is his caregiver, and part of the Medicaid goes to that care and to various other things. Well, she was approached by the Service Employees International Union, which had organized a group of these personal care workers, and told that she would either have to join the union or she'd have to pay her fair share fee. She said, well, I don't want to be part of the union and I don't want to pay a fair share fee.
She brought suit. Just trying to take care of my son.
Just trying to take care of my son. She brought suit And there are actually, I think there are 8 total plaintiffs in this, 7 of whom are in Pamela Harris's situation where they're not a state employee, they're a caregiver to a relative. So this went all the way to the U.S. Supreme Court. Now the unions were arguing that a 1977 Supreme Court case called Abood versus Detroit Board of Education upheld their right to collect these fair share fees. But the U.S. Supreme Court in June said, no, it doesn't, because Pamela Harris and these other plaintiffs can't really be considered state employees. Okay, that's a very narrow interpretation. It doesn't knock out the whole principle of collecting fair share fees from non-union members, but there was a lot of language in that decision that was basically Justice Sam Alito wrote the decision. In his decision, he basically said, well, this case doesn't give us enough to knock that totally out, but if you give us the right case, we might think about it. And here's a few of the quotes from that decision. He says, the Abood court also failed to appreciate the distinction between core union speech in the public sector and core union speech in the private sector, as well as the conceptual difficulty of distinguishing union expenditures for collective bargaining from those designed for political purposes. So it gets mixed up. There's a lot of that kind of language in there that says, well, we think we've got some problems with this 1977 case, so Governor Rauner is hoping that now, with his motion, making his point that, listen, if a union is negotiating with the government for salary and benefits, that is inherently a political activity, and we would like a ruling from the Supreme Court on this. So now the question is, does the court accept the case?
Right, and it would have nationwide ramifications in this case. And so explain for everyone also the First Amendment angle in all of this.
The First Amendment angle is that Governor Rauner is arguing that by making these non-union employees who don't want to be affiliated with the union, by making them pay their fair share fees, that you are forcing them to associate and you are forcing them to express opinions that they don't want to express through the union. Now,
so you're violating their free speech amendments.
Yes.
Okay. That's a whole lot to take on pretty early on in this administration, and some people think it may have poisoned relations with the Democrats and even some Republicans who come from union territory, but it's going to play out in court, so stay tuned because we'll be taking care of watching it all for you and share our observations. Thanks for watching this week. We'll see you on the next edition of Only in Illinois.